Hi, Mr. Franklin. Oh, okay. There's Mr. Lorado. Hello, Mr. Lorado.
Good morning, Your Honor.
Let me, before you get started, Mr. Franklin and Mr. Lorado and the rest of the panel, I have an issue that I want to kind of get clarification from you guys on to be sure I understand it correctly, because frankly, I have some concern about I know this has been hashed in this court before, but I have some concern about the finality of this order. I got to have the scenario right. The judge entered an order and that says, in part, a default judgment is hereby entered in the matter against defendant for failure to timely file an answer. And also had the provision about shall show cause within so many days why they shouldn't be held in contempt. Geico appealed that. And the day before that notice of appeal was filed, Shazam filed a motion for entry of judgment setting forth the damages. Correct? That's how I see the record.
Yes.
And then, and I assume that nothing has ever happened with that. I mean, I know we're going off the record here, but then there's a motion to dismiss the appeal saying this was a judicial default and a non-final order to show cause. And Geico, we ordered Geico to respond, and Geico says, given that representation by Shazam, we agree, and you should dismiss the appeal. Correct? I mean, and then my understanding is that, of course, at that point, this court, not me, but this court said motion to dismiss is granted as to the order to show cause, but not as to the quote default judgment.
Yeah.
If we treat that judgment as final, it's a judgment that does not award any damages or provide for any execution. So, and if any of you have any food for thought that comes to you during, I'll let you argue on your merits stuff, but I have some concerns about whether the default judgment term in that order was a misnomer versus an actual final and appealable order.
I can give you my position, Judge.
Okay.
I don't think it's a final order because there's
position was set forth in your motion to dismiss.
There's still work to be done by the trial court.
Yeah, that's what I thought. Anyway, and Mr. Franklin, you can address it now or address it as you argue your merits. But I hate to throw this curveball at you guys like this, but you know, there it is.
Yeah, if I may briefly, Your Honor, I think one of the challenges that you or we face here, and I can understand where Shazam was coming from, is even within the small claims rules, the lack of clarity on that whole mechanism and how things flow. And so there is within the rules some space for varying interpretations. If we looked at this civil procedure rules, I would be hard pressed to say anything contrary, which is why Geico said based upon the representations.
Okay, you just didn't want to be caught up short. If you right, I get where you were coming from.
Yeah.
Okay.
Yeah.
All right. Well, okay. I'm going to let that bubble and start the clock and let you start arguing, Mr. Franklin.
Very well. May it please the court, Jonathan Franklin on behalf of Geico. If I may, Your Honors, reserve 4 minutes, I would appreciate that. I think the court has touched on one of the issues that we will delve into a little bit here in a moment, and that's what do the small claims rules provide and what are we looking at? But be that as it may, the order before the court is an order entering default judgment against Geico after Geico filed its answer and without a hearing. We have contended in the initial briefing, and again in the reply, that the ruling is a result of fundamental error that Geico's due process rights were violated, and the court abused any discretion it could possibly have here. Importantly, as we look at this, and it's significant that we're in the small claims court, and so there's not a lot of DCA discussion. We do cite to Moorburger.
We try to keep it that way.
Yeah, well, that's no longer things to
Right.
the change in the
No longer an option.
no
I get it.
longer an option. But even this court back in, and I apologize for not knowing the year off the top of my head, but it's cited in Moorburger. This court, I think in 1984, recognized the small claims court as a people's court. The technicalities that you would see in civil procedure should not be there. The objective is to ensure justice for all. And so
But,
as we
I
go,
was thinking about this argument, Mr. Franklin, which is you're arguing basically there's no provision in the small claims rules for this sort of judicial default. Blah, blah, blah.
right.
But if you look at there's a rule 7.020 in small claims, it says applicability of rules of civil procedure, and you hop down to C. It's, in A, it lists certain civil procedure rules that always apply.
Yeah.
And then it has discovery. And then C says the court may order that an action proceed under one or more additional Florida rules of civil procedure on application of any party or stipulation or on the court's own motion. And I know there was no order that says the default rule will apply here, but isn't that implicitly what the judge did?
Well, if we take that argument, I'm going to key in on the word implicitly. Geico's entitled to notice. Geico's entitled to understand that the court's going to do that.
Okay.
The order doesn't take that into consideration and gives no indication on it. Yes.
But I think then your next argument, which you have made in your brief, is even if that applies, you had already filed your answer. You are entitled to a hearing.
I wanted to ask you a question
That
about that. Is there any dispute that Geico actually did file the answer before the default judgment was entered? Is that disputed?
I'm not aware of any, and I think all the parties would be hard pressed to contradict.
They
what
both
the
happened on the
docket
same
says.
day, as I understood it. Is that right?
Yes, technically speaking, Geico's answer was filed at 9:28 a.m. and the court executed, and I want to emphasize that, executed its order at 4:35 p.m. So there is a time delta there of significance. So to my knowledge, it hasn't been raised in this appeal, and I don't believe anyone could.
And in any event, at the time of the default, even if that hadn't been the case, you had a pending outstanding motion for extension of time. Is that correct?
That is correct. And we recognize the Supreme Court has spoken to this, that it's not an automatic extension. Right. And we're not unmindful of that. But I think if we go back to this, the trial court, even if it wanted to avail itself to the Florida rules of civil procedure, it would still need to satisfy due process, give us notice. It was required to follow the rules, and that comes out of In re BB, out of this court in 2003. Speaking of pleadings, generally, there is no requirement to file an answer. There's also no mechanism to file an amended statement without the court speaking into that. So what you have is on November 16, 2021, the court deems their amended statement as filed as of that date and then lists certain deadlines. Geico sought an extension on December 3rd. Mr. Lotto will probably, or Shazam will probably speak into the propriety of all that, but it did. 10 days later, 5 days after the answer was due, Shazam moved for default and moved for sanctions. In between then and the court's ruling, the court, and it's contained within the email communications that were supplementally filed in the appeal, the court asks, or pardon me, Shazam asked for a hearing. The court's judicial assistant responds, stating that judge wants a proposed order. The next day, and that's on December 15th, December 13th, the next day on, or let's see, get my dates right, December 16th, Geico's asking for clarification on the proposed order. And it then files its answer. It's only afterwards that the court takes action on that. So if we're going to take the argument that Your Honor, Judge Northcourt had suggested that the court could avail itself under subsection C of, I think you said it was 7.020, then it's running right into the body of law that says, one, we can plead at any time up to a default, which was done. And two, this court has made plain that it's error for a trial court to enter a default after an answer has been filed. Moving through that, again, we do adhere to the principle that the small claims rules do not provide a mechanism for default for failing to plead. To do otherwise, again, gets us back to due process. Going back to the case management order, I want to draw a couple of things out for the court. The amended statement was deemed filed on November 16th. There was no hard stop deadline for the answer. The court did not say you may not seek an extension. The court did not say no further extensions will be permitted. Was the court irritated for any number of reasons? Perhaps, but that is not what's in the order. There is no notice of a risk of sanction or default for failing to answer. When GEICO answers, the motion that is pending and the only deadline that is in play is the answer. But by the time GEICO answers, that deadline is no longer active. So the idea that this somehow reflected the court entering sanctions against GEICO as suggested in the answer brief is disingenuous, and it's contradicted by the evidence and the record and the facts. Nowhere even in that motion for sanctions does the court state it is entering sanctions. It states that it will determine whether, or for GEICO to show cause why it should not be held in contempt. Going back to the motion to dismiss on that was filed initially, there was discussion of that. And I think Shazam made its position very plain. The court did not make findings of contempt or sanctions. Now, in terms of that order, it only directs GEICO to show cause regarding contempt, no mention of sanctions. Importantly, it doesn't make any findings, and how could it? The order was prepared by Shazam and sent to the court, and the court refused to hold a hearing on it. The court didn't elicit any input on this and just summarily enters it. Again, I go back to GEICO has the right to answer before default if we're applying the rules of civil procedure. There really is no mechanism here under the small claims rules. We would submit either scenario. GEICO had filed its answer. This leads me to due process. And I want to make a point here because there's an argument that's been advanced in the answer brief that GEICO somehow waived something. I think GEICO has every reason and right to rely upon representations to this court that lead to orders that were entered, particularly on the sanctions. And we do cite in the reply to the anti-gotcha rule that is referenced perhaps all the way back with Judge Schwartz here in the 3rd DCA in Salcedo. But importantly, we did argue the court abused its discretion. No reasonable person would conclude that the rules permit this type of a default or a default after the answer, and I'm referring to the small claims rules. But also, GEICO is entitled to fair treatment under the law. And even within the confines of the small claims court, where justice is the greater purpose, if the court is going to take actions, the court must still administer justice where substantive rights are at issue. And that means protecting GEICO's due process. GEICO is entitled to fair notice. It did not receive it. As evidenced by the email communications, it was, I'm entering an order, you're not going to get a chance to hear. It was entitled to a real opportunity to be heard, which required giving GEICO a meaningful time to be heard and providing in a meaningful manner. All of those requirements were breached. The notion that the court's order rose to a level of sanctions, I think it's important to compare the motion to dismiss with the argument advanced in the answer brief. The motion to dismiss makes the point and states the trial court made no findings of contempt or sanctions. In the answer brief, Shazam supplies all sorts of bases for the court's supposed findings that are nowhere in the record. And importantly, in terms of what was in play in terms of deadlines as of the order on December 16th, it was the answer and whether it was timely filed. The answer was filed before that default. This type of process is an abuse of discretion. Whatever discretion the court would have had here, we would say that submit as referenced in the brief. There is no explicit willful compliance findings of any sort. GEICO is still deprived of its due process rights and a fair opportunity to be heard if this were a sanction, which it was not. So for those reasons, we ask the court to reverse the default judgment unless the court determines that it is a non-final order. On that issue, I'll briefly speak. I really don't know how to address it because of the way the small claims rules are framed. I have been intrigued by all the gaps, but I also understand small claims is intended to be a more relaxed environment. But because of that, I don't believe GEICO's due process's rights are any less important. In fact, they're more important, and it's incumbent upon the court to take measures to protect those rights. Those were all violated. So for those reasons, we ask the court to reverse and order the proceeding to proceed. If the court were to determine that it's not a final judgment, we do run into another wrinkle, which is there is no corresponding motion to set aside a default in the small claims rules and some other things, but perhaps in the context of applying it as a default under the civil rules, as well as this court's decisions in Pinnacle and other cases, pleading before the default will be fine. If the court has any questions, I'd be happy to answer them. Otherwise, I'll yield the remainder of my, or yield to Shazam and reserve the remainder for rebuttal.
And then after the case is over, we can all get together and write a bar journal article about this conundrum.
I would love to. I'm not sure if my camera froze. It looks like it did, so I apologize.
It did, but that's okay. We could hear you fine. All right, Mr. Lorado, you're up.
Hey, good morning, man. Please the court. Michael Lorado. I represent Shazam. Initially, I want to address the finality of the order here. I've never believed once I got involved in the case that the order was final, namely because there's still the matter of damages on behalf of the plaintiff that has to be
Do you
determined.
agree the use of the word or term default judgment in that order was just a misnomer?
I think it was, and I think it doesn't add the requisite language of finality given the context.
Can an order have language of finality but still leave the core issue of the judicial labor being undone? I mean, you know, 'cause that term judgment was the language of finality, which I have a feeling is where this court went off, possibly off track. Still, it's clear that the judicial labor was not completed at that point.
Absolutely not, and not intended by any party, understanding that the order on appeal says final judgment. I would, in terms of the jurisprudence on this, I would equate it to an order granting final summary judgment. If that order doesn't have the final words of finality, an order granting summary judgment is not appealable or final. If there's still judicial labor to be done, and on this particular case, I think there is, in terms of the import of the order and the fact that that there's still damages to be resolved here in this particular case. That said, I'll address the merits. I'm unclear about the particular case that Mr. Franklin believes is on appeal, because it's clear in this case, and again, I wasn't the trial lawyer, but what I see from the record is that there was a case management conference called by the trial court judge, because the trial court judge was particularly perturbed, to use Mr. Franklin's words, about the progress of the case. So at that case management conference, which it's in this particular record, the court addresses all these unsettled and unfinished issues that have to be done, and that the court wanted done. At that case management conference, the court said, look, I want to be entirely clear to both parties about why I'm going to enter this order. It's because we are under strict time frames in order to complete this case pursuant to Supreme Court orders and other circuit court orders here. The reason I'm doing this is for that reason. And I expect strict compliance or words to that effect. There is a detailed conference and all the issues involved in the case. At the conclusion of that conference, GEICO is ordered over numerous objections, and over all the objections that we hear from Mr. Franklin, that an answer isn't required in small claims court, that there's no procedural vehicle to require an answer to court, that there was no procedural vehicle to permit an amended complaint. The court deems the amended complaint files, orders GEICO to file an answer, and orders it also to complete some outstanding discovery by a certain time frame. What happens next is that from the record I see is that GEICO doesn't file an answer. It seeks rehearing. The court denies that. It attempts to re-argue matters and further delay. And ultimately, what the court does in this case is there is a motion presented, and the motion is one for sanctions and contempt for failing to comply with the order. The motion is found at page 88 through 103 of the record. And the motion specifically requests that the court grant a default for GEICO's failure to comply with the order at the pretrial conference, and specifically for not filing an answer. GEICO requests that sanctions be entered.
Would you argue that that then constituted your request to apply the applicable rule of civil procedure on the default for failure to answer?
If my memory serves me correctly, I believe that the court itself, during the case management conference, because there is a transcript of that, the court itself does address the fact that it is applying the rules of civil procedure to this case.
Okay.
So everyone, again, if my memory serves me correct about the record, but I do believe that the trial court in the case management conference said, look, we are operating under the rules of civil procedure, and I have the authority to do that.
Frankly, to tell you the truth, if that were the case, it would simplify a potential issue that Mr. Franklin raised, which is if we find this is a non-final order and dismiss the appeal, it resets, puts the parties back in the position they were in, which is a default has been entered in a case in which the rules of civil procedure have been applied in that respect. And then, he could seek to set it aside or what have you. It wouldn't be in this ether.
I think the issue in this case boils down to whether a trial court has in its sanction panoply, whether it can apply an extra rule default for the violation.
You acknowledge that the order as written in terms of whether the default was entered for failure to file an answer or as a sanction for failure to file an answer is ambiguous.
I don't believe so, because I believe that the order grants the motion as filed, which is again on pages 88 through 103, which requests sanctions. And then it also requests to hold them in contempt and for them to show cause. Those are two different issues. Why they didn't and whether their conduct was contemptuous is an entirely different issue about whether they violated the order. And I believe that there's plenty of authority where a court is vested with discretion to fashion a sanction based on the violation of an order, regardless of whether there is a rule of procedure which also permits that same sanction. So Mr. Franklin's argument is that there's no rule of procedure which permits a default for failure to answer, but there is jurisprudence which permits a court to enter a default as a sanction for violating a court order, regardless of whether the rules of civil procedure apply or not. And in fact, in this particular case, following the case management conference, there was actually a written order on case management conference. There were two of them. And there was a subsequent one that said, in the event that a party violates any order at a case management conference or anything in a case management order, the court is authorized to grant sanctions, including and up to a default. That's all the court did here. The court held a case management conference, ordered Geico to do certain things. They didn't do that. Based on the record in this case, regardless of whether the rules of procedure either did or did not permit her to enter a default for failing to plead, the court was authorized and well within its discretion to take Geico's, what it considered to be Geico's dilatory conduct, which called for the first case management conference in the first place, and then its subsequent conduct as a willful violation of its order. And probably the most important item in this record from a merits perspective is the transcript of the case management conference order, where the court is clearly perturbed with, why isn't this case moving forward? Why haven't you answered discovery, Geico? Why haven't you filed an answer? What are your defenses? Why haven't you allowed for depositions? Why hasn't that happened? This case has been pending for 6 months. It heard all of Geico's arguments. At the conclusion of that hearing, he said, I'm going to tell you what I'm going to do and why I'm going to do it. And this is what you need to do. And one of those things was filing an answer, and Geico clearly didn't do it. And more than that, we haven't heard Geico posit any excusable neglect or reason for not doing it. There was none posited to the trial court in its motion for rehearing on that case management conference order. There was no reason posited other than a regurgitation that they don't have to file an answer under the applicable rules, and that they're entitled to a stay, which the court also had considered during the case management conference, and anything other than that they had been ordered to answer explicitly by the court at a case management conference, and they didn't want to do it. So the court, faced with that and faced with that recalcitrance, was free to view that as the willful violation of an order and sanction Geico appropriately. One of those sanctions was a default. That's what the court did. Geico, I think, in order to have that reversed, would have to show that the court abused its discretion in exercising that sanction and entering a default as a sanction for its failure to comply with its order telling Geico to do certain things, one of which was filing an answer. Geico hasn't posited anything, and more than that, Geico has simply refocused this appeal that there's no rule of procedure which permits the court to enter a default, without focusing on the actual procedural context in which this default was ordered. And it wasn't ordered under a rule of procedure. It was ordered under the court's inherent authority to manage the litigation and the parties in front of it. And when a court is faced with a party that doesn't want to follow its orders, right, wrong, or indifferent. For example, this court's order to Geico could have been completely not supported. It was nevertheless an order. Geico's motion for rehearing didn't stay it. It doesn't mean that they don't have to comply with it. Regularly, when courts are faced with people or litigants that don't follow their orders, courts regularly enter sanctions, and they have, when it's a willful violation of an order, they have the authority to enter a default judgment, and that default judgment is only reviewed, or enter a default against the party. Excuse me, I'm falling into the same trap that the trial court order had here, in this case, to enter a default against the party. And then that order is only reversible in the event that the appellant, Geico in this case, can demonstrate abuse of discretion. And they have made no argument in their initial brief about that. The only argument that they've made is that the trial court abused its discretion in entering a default for failure to plead. But that's not at all what the record shows here. The record shows that there was an order which ordered Geico to file an answer, and Geico didn't do that. And it was a sanction entered for the failure to follow a court order. In any event, I don't believe this is a final appealable order, but in the event the court does consider it to be a final appealable order, the order on appeal should be affirmed. Thank you all.
Okay, Mr. Franklin. You're muted, Mr. Franklin.
I got
There
the
you go.
camera to work and then I turned off the mic. So
You can go.
uh, all the issues that are presented here from both sides still run into the same problem, which is Geico's due process rights were violated. There is no notice of an intent to sanction in this manner, and there is no opportunity to be provided to Geico to be heard. The email communications between the courts, JA and Shazam, demonstrate the court wasn't going to have a hearing, thereby stripping Geico of its opportunity to be heard. There was no advance notice of any sanction or anything remotely to this level. The idea that this court was acting and consciously analyzing all the issues to put together this order is betrayed by the fact that the order is nothing more than a proposed order submitted to the court by Shazam. The statement that there was a second case management order that threatened sanctions is a mischaracterization of the order. The order is a differentiated case management order found at record page 104. It is to apply to all cases filed before April 30th, 2021. The order plainly states failure to comply with any part of this DCM, differentiated case management, or may result in dismissal and going on to reference default. It has nothing to do with the case management conference. The next thing, the idea that there were findings by the court, again, there's nothing in the record to show any type of findings. I am still going to go back to the anti-gotcha rule. Shazam presented argument to this court that the court made no finding of contempt nor sanctions in its motion to dismiss. The court accepted that, dismissed that part of the appeal for reasons known to the judge that signed the order, shows that the default judgment is still pending, which is what we've addressed at the outset. And now Shazam comes in and claims, oh, it was a sanction order, and let Shazam provide for the court all the possible reasons. Not one of those reasons is ever stated anywhere. The notion that the civil rules of procedure were invoked, I don't find it in the transcript, but as the court has mentioned, if they do apply, we're right back into Pinnacle, and this is a non-issue. So for the reasons stated initially, unless this court has any questions, we are going to ask that the court reverse and remand this matter back for proceedings consistent with Florida law in governing these matters.
Okay.
Thank you.
Thank you, Mr. Franklin. Let me say, because obviously now we have three possibilities. We can affirm, we can reverse, we can dismiss for lack of jurisdiction. And on the latter, let me point out the way the court works internally, and I think these are on the IOPs on our website, is, motions before a case is assigned to a panel, which is done after all the briefing is in. Motions come in and they go to a motions panel, which may or may not include judges who are eventually on the merits panel. But so the motions panel did what it did. And obviously, if we think that was incorrect, then we believe we don't have jurisdiction. And so we have to dismiss the case. And I apologize that it came up so late in the proceeding, but that's just how it works sometimes.
Yeah, and Your Honor, and we noted at footnote 1, the ruling, because we recognize what we were dealing with. That we're not hiding from that.
No, I get it. It's just, I feel bad that you spent all your briefing the case, and here you are. Of course, Mr. Loreno kind of gained some fee there. I'm joking.
I learned so much about small claims and all this. I knew of the anti-gotcha rule, but not as the anti-gotcha rule. It's always a worthwhile expedition.
Yeah, there you go. Okay. So you guys need to leave our little virtual space here, and you do that by clicking the leave button on your Zoom screen, and you'll head off into the ether, and we'll call our last case.
All right. Thank you very much, Your Honors. Happy holidays to all.
Same to you.
Cheers.